The university's been involved in research in Strata for about 3 or 4 years, and whilst I was in private practice I did some work with them. So now that I'm consulting, they asked if I'd like to help them with the research work, and I'm now on a part-time basis spending time with them, assisting with the structuring of the research, helping understand the legal and other issues around that, and also working with them to develop new research areas and research ideas. Of course. One of the things that I realised in doing my legal work was that you couldn't actually solve a person's problem in Strata just as a lawyer. You needed to involve other people. So I've decided that some of the harder problems in Strata to solve and some of the better solutions come with a multidisciplinary solution to that problem. And so the Strata Experts is something that's not a law firm and not a consultancy. It's a bit of everything, so that I can see the problem and analyse it, work out who the best people are to fix it, and then make sure it happens for a client, rather than I'll only provide them a legal solution. No, I'm working for developers, buildings themselves, some managers, other business sectors. Anyone that's got an interest in or an issue with a medium or high density building, I can assist. So it could be anyone or anything. So at the moment I'm not looking for a lot of clients, I'm just looking for people who've got a serious problem that's interesting and that I think I can add value to. Well, every day sometimes there's a bit too much strata, but it keeps dragging me back. I suppose it's what I've known. I've worked in it for a long time, and people keep asking me, about what I know. So it's hard to resist that. I was around when it started, and in fact we opened in Melbourne around the time the legislation started for a few years. And I thought that it would sort of take off in a big rush, and I was surprised that apart from the managers, most of the rest of Strata land didn't seem to notice it happened. So it's, in a sense, it's sort of slipped a bit under the radar. I think with the more recent reforms this year, obviously people are starting to work with it more and more. So it's had a slower start, I think, is my main observation, than I imagined it would. I think it's a good piece of legislation as an overall, where it fits in the Australian regime. It's clever, it's intelligent, it picks up some of the best things from around the country, and I think it's a good set of rules that will last a long time. Not yet. I mean, there's more than there used to be, but inevitably that's the way laws will go. But I think it's got a reasonable balance at the moment. Not just in Victoria, all around the country, I think that committees need more powers. I think that powers have been taken off committees, and that's not really the point. The point is that they're elected to represent the owners and make decisions for them, and they should be allowed to make those decisions. The solution isn't to take away their powers if they do it wrong, it's to change the committee. So I think that's a change that I'd like to see: more power to committees than less power. And I think that probably some clarification in the legislation about when a minority is right and wrong. I think this is a challenging issue for the future, that just because an owner disagrees with a decision doesn't mean they're right and doesn't mean they're wrong. But when is a small minority who's opposed to the majority are allowed to be right, and when do they need to just go along with the decision making? I think that's a challenge all around the country, and I don't think anyone's addressed it yet well. I can see both sides of the argument. I can see that if someone is elected to be a committee member, they ought to be there making the decision, not someone they appoint to substitute for them. But at the end of the day, I also think that it's important that committee meetings work and that they have a quorum and they can make decisions. So if this mechanism allows more committee meetings to proceed and make effective decisions, then I think it's useful. It's fairly common all around the legislations that I've worked with that there is an ability for a committee member to appoint a proxy, so I don't think it's out of sync. But I think that a committee member who doesn't ever turn up and only sends a proxy is probably unlikely to get re-elected. So it'll get fixed in its own right with proper awareness. Well, it sort of does go back to Foss and Harbottle, which was a case about whether a shareholder in a company could enforce the rights of the company against a third party. And so really the issue is, if an owner's corporation has a right to enforce something against an owner, but it chooses not to, for good or bad reasons, should an owner be able to go and pick up that slack, essentially, and do it themselves? And there are many views that say if the owner's corporation decides not to or doesn't, then the owners can't interfere. There are other views that if the provision is there to protect people in the building, then, and an owner's corporation fails to deal with it, why shouldn't an owner who's prepared to spend the money and do it themselves do it? I think it's right that an owner should be able to do it. I don't think there's anything wrong with it. And I think the instances where they will be very limited. If they do and it's successful and they were correct, well, it only vindicates their position. And if they fail, well, it vindicates the owner's corporation's position. And I don't think that the owner's corporation is worse off by having that provision. The obligations of committees are fairly complicated. It's still not settled in Australia exactly whether they act like company directors or they have a lesser duty or a different duty, and it's probably less than a company director. Having said that, they have some fiduciary duties, so they must act in good faith, they must act honestly, and they must act in the best interest of the strata corporation or the owner's corporation. There's probably also some requirements that they do implement decisions that are generally in the best interest. The real problem becomes who decides and how you assess whether this decision is or isn't. So I don't think it's wrong for them not to enforce an obligation against an owner when the owner may have breached it, but they ought to have good reasons for doing it or not doing it in both cases, because they can be criticised either way. And it's more about them thinking about it and coming to a decision based on reasons, rather than having either a policy that they don't do it or just dismissing it for no valid reason or a wrong reason. That's more important. Oh, okay. Well, there's been lots of cases. I think one of the important cases has been the Arrow case in New South Wales, which was about the developers' obligations to owners and in relation and establishing that they had a fiduciary duty, so that when they created a strata scheme they couldn't make secret profits by entering long-term management contracts. I think that's important because it defines the relationship between the person who creates a strata scheme and the ultimate owners. That's never existed before, so that's very important. There's been a series of cases around the country where courts have approved the variation of existing schemes where they didn't work or they were developed in a way inconsistent with the original plans, so that the owners have gone and rejigged those schemes, including changing the boundaries, moving property into community or shared property. I think those cases are important. And I think what's been important in the last 5 years has been all the cases around levy and fee recovery. The debate about what should an owner pay when they haven't paid their levies. The levy, the interest and the recovery costs has been important because it's highlighted how important it is that the scheme gets its cash flow and that the consequences of not getting its cash flow really are serious, and the courts have generally been happy to impose those reasonably on owners who've caused them. So I think they're the three areas of recent cases that affect strata scheme operation. Some years ago we were involved in a case of all things about a cat. So it's often the small things that create the most biggest problems, and they create the most challenging issues. And so we had a lady in a strata scheme that was keeping cats. No one could work out how many because no one could get into her apartment, but they could hear lots of meowing and lots of scurrying, and there were some smells. They assumed there were 5, 6, 7 or 8 or 9. After about 2 years of various action to try and enforce the rules and bylaws and prosecute her and flush the situation out, they eventually got in because of a plumbing leak and found that there were well over 50 cats living with this lady in a 2-bedroom apartment. And it wasn't really all that funny, but it was a shock to everyone that we thought we were chasing half a dozen. It turned out we were chasing more than half a dozen. So, you know, sometimes strata throws up some very interesting surprises, even for lawyers. Well, she moved out because she was ill. The cats were removed by the RSPCA. The apartment was cleaned by emergency cleaning contractors so that it was clean. But I'm told that when she finally moved back in, she started to build up her cat collection again. And I haven't heard about that again. So I guess once it gets to 50, you never know, we might be back on the job. Oh, that's a really good question, because it's something I've seen a lot of. If an owner's corporation needs advice, they should go and get it early, not late. That's the first tip. I know it seems like I'm promoting the use of lawyers, and I'm not really. I'm simply saying that if you go too late to get the advice, not only will it cost more, because there'll be more to consider, you may have found that your position's already prejudiced, or options that were available to you are too late to exercise. So early advice is always more cost effective than late advice, because there's always gives you more options, and it's probably going to be easy to get. The second is to go to someone who specialises, who's got some experience, has worked in that area before, and understands body corporate law, owners corporation law, or strata law. So it's important. And you can get recommendations, you can check, you can ask for references. So it's important to use someone who actually has a commitment to the area and has practiced in it and understands it. The third is something that an old friend of mine said, it's if you pay for advice, take it. Their saying was, why have a dog and bark yourself? In other words, once you've seen the lawyers and you've gotten the advice, unless there's a seriously glaring problem with it, and you should take that up with them straight away, you should follow the advice. Not following it is pointless. You may as well not have bothered. And in fact, if it turns out that what you do is wrong and you got the advice and failed to follow it, then you're in an even worse position. So fairly simple advice, act quickly, use someone who knows what they're doing, and listen to what they tell you, so there's nothing too technical about that. Interesting. Well, there's lots and lots of decisions and rules around the world. I think some of the more interesting things in terms of the future are that in the USA we're seeing the recognition of rights with people with disabilities transferring into the way strata schemes are run and operate. So situations where people who are less mobile than others are applying to have their car parking spaces reallocated in the strata scheme so they're closer to a lift or a ramp. People asking the Owners Corporation to install wheelchair lifts into swimming pools where there aren't, or wheelchair access in a building that never had them. And the court's saying yes, that they have to change the allocations. Now they're interesting because they're taking social policy law around disability and recognising the needs of people with disabilities and cutting across property law. So they're saying, well, we can change who owns which parking space to deal with a disability. We can add to a common property and add to the facilities in a building when it wouldn't otherwise have them because it's accommodating a disability. And I think that's a very interesting trend that will inevitably spread throughout the world, so that buildings will need to be adapted and people's rights and expectations will change given the nature of the occupier. So that's quite new, and I think that's very interesting. So far there's not been any case that's recognised that. There's been some people who've argued that their disabilities, that they've been discriminated against because of a disability in terms of decision or the way a scheme runs, say to keeping an animal or in terms of some alteration of the building, but no court's upheld that as yet, and the laws around Australia don't track that far. But there will be reform as they are with social policy, and I think you'll see an opening, and then someone will argue it when the issue is serious enough. Australia's a leader in many ways. It was one of the first countries in the world to have strata titles, and it's exported its laws to many countries around the world in Western thinking. And management practices in Australia are quite sophisticated and quite involved and highly regulated. So Australia is one of the leaders. I think Canada has a lot of interesting and innovative laws. They're a leader in terms of recognising the rights of tenants in strata scheme and understanding how the tenant-owner relationship works. And certainly the USA is a leader in many ways because it's got so many strata schemes and condominiums that it's experienced lots of issues and is probably the most prolific in terms of cases. But on the other hand, you've had a kind of strata title law in France for over 200 years. So, you could look anywhere in the world and find clever innovations and ideas. But certainly Australia and Canada, I think, have a very active, modern strata title system that is looked at by most people around the world as for examples of what to do. I visited Dubai, and some of my colleagues and other people I know work in Dubai in the space, and it's amazing what they've done, not only in terms of the scale, because it's a huge amount of development, but also the innovative styles of buildings that they've built and strata titled. There's a building in Dubai which rotates, but it's not just the whole building that rotates, every floor rotates individually and is on a separate title. And one of the challenges that they had there was how to create a title for the central section where it moved around and it wasn't in a fixed position. So, and they found a solution because they want to find a solution. So Dubai is a great place. They decide they want to do something and they work out how afterwards, and that includes laws and operating systems. Well, South Africa's laws are based on the New South Wales law, so in many ways the system, the operating of strata schemes and the way managers work is very similar. And culturally it's not that different to Australia in terms of its legal and property systems. It's got some challenges that are different to Australia. Obviously the black population is much poorer than we experience with strata ownership in Australia, so they have a big problem with arrears and also just the education of people who own strata title. They also have some serious problems in terms of regulation. Licensing of managers is at a very low level, so they experience a lot of problems with illegal operators and operators who are just not following not only good business practices but legal behaviours in relation to how they run the buildings and how they manage people's money. So much more challenging environment legally over there than it is in Australia. Well, I'm only the chair, so it's not really up to me, although I get to moderate the lawyers. I've done that for the last 3 conferences, so it's a legal roundup where I try and get a lawyer from each different state to talk about an area, and then we compare and contrast how it works from state to state. I think we'll definitely be talking about strata levies because it's been a hot topic for a while and it'll continue to be. I think building defects and how they're progressing and being dealt with in each state will be another area. And we'll probably talk about some of the reforms because each state has got some reforms that have come in or are coming in 2010 in their strata laws. So there'll be 3 definite areas, and who knows what else. You'll have to come to the conference to find out. Well, by accident, like most things. When I stopped running the legal practice, I was a bit bored, so I started exploring social media for all sorts of things, my personal interests, and also see what was there in the real estate sector. And then started blogging one day just to find something to do, and then I've been blogging for, I think about 14 months now, and it's just where I find something of interest, put up a page, and it's more a hobby than anything serious, but it's sort of now become quite popular and I'm enjoying it. Business I don't know, but certainly it's helped me maintain and develop connections with people who are also interested in the area, and I think that's always useful as much as business is about networking these days. So I think it's a great way to network. I certainly think that it's changed even in the last 12 months, and I think it will continue to change, and I think anyone who's interested in communicating with people about things and ideas and information needs to at least have some awareness of how that space works. I'm following a blog called This Big City, which is actually based in London. It's about urban planning and how to make cities better places for people and for infrastructure and those, because I find that quite interesting. They feature quite a lot of good innovations around city living and city development. I'm a motor racing fan, so I follow a lot of motor racing. I like food and wine, so I eat out and drink too much. And I listen to music and spend time with my family. So they're my main things I do outside of Strata. I think the biggest challenge will be the lack of resources, that is the lack of people to do the work that's required to help run and manage these strata schemes. There just aren't enough people already, in my view, and there's not going to be enough given the increasing number of those people and how much people will need to know to do it properly.